Hi, everyone. Thank you for being here today. I'm Adam Chilton, the Dean of the University of Chicago Law School, and we're today participating in one of our great law school traditions, which is the First Monday lecture series. Now, each fall, the Supreme Court opens its new term the first Monday of October, and in advance of that, we gather some of our leading faculty members to try to talk about some of the issues that the Supreme Court is either planning to address or likely to address in this upcoming term. Now, the First Monday series is one alumni tradition that's evolved over the few years in a positive way since the pandemic, in that we used to hold these events in person in Chicago, New York, and DC, but over the last few years, we've been holding them virtually and being able to reach a much wider audience all at the same time. Now, today we have with us alumni both of the law school, but also the broader University of Chicago community, as well as members of the media that are interested in the Supreme Court. Now, I have three of my colleagues with me today that are each going to talk about different aspects of the upcoming Supreme Court term. First, Sam Bray. Sam Bray is our newest faculty member. Sam is an alumni of the law school and previously, until recently, was a professor at Notre Dame. Sam is a leading scholar who teaches remedies, civil procedures, and constitutional law. He's also the leading expert on nationwide injunctions. And in fact, in one of the last cases of the last Supreme Court term, on nationwide injunctions, Sam was cited something like 23 times for his scholarship and discussion of the topic in the opinions. Next, Jennifer No. Jennifer is a leading expert in administrative law, executive branch dynamics, regulatory policy, and constitutional separation of powers. Jennifer, in addition to being a member of our faculty, has also intermittently served in the federal government in the executive branch at OIRA and is a leading expert on admin law as a result. Finally, Kurt Bradley. Kurt Bradley is a professor that focuses on foreign relations law, international law, and federal courts, but is probably most well known for being the leading foreign relations law scholar in the country. Now, each of my colleagues is going to talk for roughly 15 minutes. Sam first is going to speak about the scope of federal remedies. Jennifer is going to talk about executive power and control over federal agencies. And then finally, Kurt about foreign affairs cases. After that, we'll then have some time for some Q&A that we'll use the Q&A box feature for. All right, that's all the introducing I'm going to do. Sam, over to you.
Thank you very much, Adam. The background for the coming term is two different conflicts. On one axis, there's the Supreme Court and the president. Back in May, it looked like there was going to be a lot of conflict over immigration enforcement and due process. But right now, the president is on a big winning streak at the Supreme Court. Watch out for more conflict here, though. The other axis is between the Supreme Court and the lower federal courts. And this is where we're seeing a lot more tension and a lot of Supreme Court reversals and stays, and even in one recent Supreme Court concurrence, some harsh rhetoric for federal judges. That axis of conflict, the vertical one between the Supreme Court and the lower federal courts, is helpful for understanding one of the big decisions from last term. That's Trump v. CASA. So in that case, the court said, in short, no more universal injunctions. When a plaintiff wins a case against the government, the court should give a remedy that protects that plaintiff or that plaintiff class, but not everyone in the country. So that much was clear from CASA. But there's a lot of unfinished business from the decision, and some of it may come back to the court in the upcoming term. One thing is the executive order in the background in CASA. That was President Trump's executive order purporting to end birthright citizenship. Birthright citizenship might get to the Supreme Court this term. Another thing is the substitutes for universal injunctions. So the most common ones here are class actions under Rule 23 of the Federal Rules of Civil Procedure and vacatur under the Administrative Procedure Act. Lower courts are starting to wrestle with these in a post-CASA world, and it's not really clear yet how that's going to shake out, especially on the vacatur front. And another big unanswered question is who controls the remedy given by the federal courts? Is it, on the one hand, the district courts and the appellate courts, or on the other hand, is it the Supreme Court? So that question of remedial control, a kind of tug of war between the Supreme Court and the lower federal courts, is going to be a driving force in the coming term. It's going to show up on what used to be called the shadow docket, a term coined by our colleague Will Bode, but now often called the emergency docket, or the interim docket, or the interim orders docket, or the interim relief docket. Lots of different names. Maybe it's the thinking fast docket as opposed to the thinking slow docket. These are catch-all terms for when the Supreme Court acts, but it hasn't had full briefing and oral argument on the merits yet. And it's usually acting quickly and without a written opinion explaining its work. My colleagues and I will probably all talk about the interim docket in some way because it's such a big part of what the court is doing. But I want to highlight how it matters for remedies. So yesterday in Nome versus Vasquez Perdomo, there was a Supreme Court order staying a district court's injunction, which had restricted the criteria the federal government could use in rounding up people in Los Angeles for possible deportation. So the district court gave an injunction and said 4 criteria were out of bounds. Apparent race, Spanish language, location, including a day labor pickup location, and type of work. So the district court said these can't be considered. The majority stayed the injunction, so the government can consider these factors. But the Supreme Court didn't explain its stay order, so we don't know why it gave it. But Justice Kavanaugh issued a concurrence just for himself. So the one member of the majority that showed his or her work. He said that, among other things, the plaintiffs in the case had no Article 3 standing to get an injunction. Now, I don't think that's a very good reason to object to the injunction here. The plaintiffs do have a very realistic chance of being arrested. And if the lawfulness of that arrest depends on what the reasons are for the stop, it's hard for them to know what the reasons are in the head of the ICE agents and whether it would or would not be lawful. So in my view, as a matter of Article 3, they have standing. On the other hand, there are problems with the injunction. And one is the difficulty of managing compliance with an injunction that says to ICE, in effect, when you make arrests, don't think about these 4 things. So in other words, if I can get into the weeds just a moment about one of the cases Justice Kavanaugh cites, the Article 3 standing argument from Lyons doesn't work here, but the equitable remedy concerns from Lyons are more on point if we transpose them from the key of federalism to the key of separation of powers. But even if the Supreme Court had good reasons to stay this injunction, there's a huge yawning void where the remedy is supposed to be here. So if it's not an injunction for an illegal or unconstitutional stop, what is it? What's it supposed to be? Another problem with the injunction is that it's unclear exactly what it forbids. Does it forbid any consideration of the 4 factors, or only a stop in which the 4 factors were dispositive? And that seems to divide Justice Kavanaugh from the dissent written by Justice Sotomayor. But the obvious answer to that problem, if the district court injunction is unclear, is to modify the injunction. That's what you do with unclear injunctions. But the Supreme Court didn't do that. And it's not even clear now that the district court can modify the injunction because it's been stayed by the Supreme Court. So in this case, you can think about this case as just a kind of microcosm of the larger issue of remedial control. So this case and the interim docket more generally force us to think about who decides the answer to whether a remedy is appropriate and when that decision happens. So traditionally, like if you did the Schoolhouse Rock version of adjudication, the sequence would have been the district court and then the Court of Appeals and then review by the Supreme Court, but only after a full dress hearing. But all of that's gone now on a lot of cases, and we're getting the legal equivalent of fast food with a line through the for the drive-through. The line is out the door. And note the irony of the Supreme Court jumping in very quickly to decide the scope of the remedy in the Los Angeles ICE case. One of the many reasons to get rid of the universal injunction was that the Supreme Court wouldn't have to do this queue jumping anymore. Trump v. Casa was a gift for the proper ordering of adjudicative process, for more deliberation and better decision-making in the courts. The oddity here is that the justices aren't accepting the gift they gave themselves in Casa. To be sure, some of the lower court decisions have been reversible and should be reversed. And on the other hand, many of the administration's most flagrantly unconstitutional actions haven't reached the court yet. like the merits of the order purporting to end birthright citizenship, or the purported suspension by the president of the TikTok statute and the domestic part of the Corporate Financial Transparency Act, as if the president could just say, like, here's a part of a statute that I'm going to suspend, or the unconstitutional attacks on law firms by the president just because they happen to displease him. But for the questions that have reached the court, the president is on a roll. Depending on how you count, it's getting close to 20 straight wins. And part of that is surely the executive branch's agenda control. The Solicitor General can decide which cases to take to the court on the interim docket. So let me wrap up with 3 more notes about remedies issues to look for. First, one of the blockbuster cases to be argued is Louisiana v. Calais, which is about the Voting Rights Act. There are several questions presented about the use of race in redistricting. I expect the court's colorblind reading of the Equal Protection Clause to keep getting extended to new areas, like electoral districts. But a sleeper issue to watch for is what the remedy is. Can the federal courts draw election maps? For decades, the federal courts have said yes, but Justice Thomas says no, and post-CASA, this question may heat up. I predict court-drawn maps are safe. Second, in another case from Louisiana called Landor, the Supreme Court has to decide whether a plaintiff can win damages from a government official under RLUIPA, the Religious Land Use and Institutionalized Persons Act. This case is a collision of 2 forces in the court's jurisprudence, like unstoppable force and immovable object. Religious liberty plaintiffs are on a long winning streak, and the court is very hostile to presuming damages actions against government officials. So what happens when these 2 forces run into each other? And in Landor, the facts are really bad for the state government. The inmate is a Rastafarian, and he told prison guards not to cut his dreadlocks, and he even handed them a copy of a Fifth Circuit opinion saying they couldn't do it, but they threw the opinion in the trash and forcibly shaved his head. I predict he's getting damages. Finally, one category of cases where the Supreme Court has frequently intervened on the interim docket is about the firing of executive branch officials. One of those firings has attracted a lot of recent attention, which is the president's attempted removal of Lisa Cook from the Federal Reserve Board of Governors. Given the president's own fraud conviction, there's some real chutzpah there, but there's no free-floating chutzpah doctrine that stops that. The closest there is unclean hands. The courts have been struggling with what the remedy should be in these cases. Should the final remedy be an injunction ordering reinstatement, or a declaratory judgment, or just back pay, or more exotic remedies like the writ of quo warranto? And they've especially been struggling with what the interim remedy should be. In the meantime, while the litigation is unfolding, should the putatively fired officials stay on the job? So here's my prediction. The courts will settle on an equilibrium of no interim remedies for removed officers, which is generally reasonable, I think, because you don't want flipping back and forth during the litigation process on who is in the office. For the final remedy, I think the question about reinstatement injunctions is going to turn out to not really matter very much. When the courts give a remedy that declares that a fired officer is the rightful holder of the office, there isn't much difference between the legal force of that judgment and an injunction ordering the officer's reinstatement. The executive branch must follow the judgment of the court. Even if that judgment is declaratory, reinstatement must follow. As Justice Scalia once wrote when he was a judge on the DC Circuit, in a different time, with a different executive, feels like in a universe far, far away. We note in this regard that the discretionary relief of declaratory judgment is, in a context such as this where federal officers are defendants, the practical equivalent of specific relief such as injunction or mandamus, since it must be presumed that federal officers will adhere to the law as declared by the court. End of quote. But whether we even get to the question of these final remedies is unclear. It depends on whether the removed officers keep losing and whether Trump continues his winning streak at the Supreme Court. I'm now going to turn the program over to my colleague, Professor Jennifer No.
Thanks, Sam. So I'm going to pick up on a whole bunch of his themes. But before doing that, I'm just going to take a quick step back. First to echo that indeed, I agree that the blockbuster cases of this term have yet to be granted after appearances on the emergency shadow interim relief docket. But to maintain its institutional reputation, at least some of the justices I think are very concerned about that. I predict the court is likely going to split the baby in some ways when it comes to wins for the Trump administration. It doesn't seem like it quite yet, but I think some of the merits cases that are percolating might provide some opportunities for that, although I do think that the net result is going to be an increase in the institutional power of the president. In support of this claim, I'm going to just touch upon three dynamics I think at play in this upcoming term that will, on the one hand, increase presidential control. And then I'm going to end with, I think, a dynamic that could leaven some of these wins, cut in the other direction. And that is what I will talk about in terms of the implications of a case called Loper-Bright, which essentially calls for independent statutory interpretation by courts rather than deference to executive branch statutory interpretation. On the three dynamics that I think will collectively augment presidential control, I'm going to first talk about the near complete victory of unitary executive theory. Goes by many different characterizations, but one key premise of it is that the president has untrammeled control over removal of executive branch officials. Second, a potentially neutered major questions doctrine. We had some indications that various justices of the court, principally, I'm thinking of Kavanaugh's concurrence last term in a case called FCC versus Consumer Research, suggesting essentially that the court is going to pull back on what I'll just call MQD for short, given the emergence of Loper-Bright, which I've already described. And then I'm just going to touch briefly on presidential control over federal elections, which indirectly is going to come up through a case called National Republican Senatorial Committee versus FEC. As I said, on the other side of the ledger is Loper-Bright, and there I will talk about two cases, one of which has been recently dismissed. Those cases are Urias-Orellana versus Bondi, basically dealing with deference to fact-finding by BIA judges, and the other is the dismissed case of Department of Education versus career colleges, which basically dealt with a Biden-era borrower defense rule from the Department of Education. Okay, so first, let's begin with the near complete victory of the theory of the unitary executive. For years, as many folks in the audience know, the court has been steadily chipping away at a key precedent, the key precedent of Humphrey's executor, which dealt with removal restrictions that Congress placed on commissioners of the 1935 Federal Trade Commission. I say 1935 Federal Trade Commission because the actions of Justice Roberts yesterday in dismissing, or rather pausing the DC Circuit's attempt to reinstate Rebecca Slaughter of the FTC suggests that the Supreme Court thinks that the modern FTC is no longer valid under Humphrey's executor. This chipping away, I think this administration has basically given the court various vehicles and opportunities to, if not completely overrule Humphrey's executor, at least narrow it even further from the two exceptions from a case decided a few terms ago, Salala versus CFPB, essentially restricting these removal restrictions only to particular inferior officers, and as I said, the narrow facts of the 1935 FTC. Some of those cases and vehicles include, again, from the interim docket, Trump versus Wilcox, of course, where the court basically effectively allowed for litigation to proceed regarding the Trump's dismissal of members of the National Labor Relations Board and the Merit Systems Protection Board on the grounds that both of these agencies exercise considerable executive power, basically implying that the removal restrictions are unconstitutional. Now, of course, very famously, and this is why I keep saying near complete victory, in that case, the court went out of its way to carve out the special status of the Federal Reserve. Essentially, of course, the court says that the Federal Reserve is unique because it is quasi private and also follows in the historical tradition of the first and second Bank of the United States. That claim is the subject of a lot of academic commentary and debate, and I think that there are really good arguments to the contrary. Essentially that the bank is public and is not doesn't have a distinct historical tradition, that it follows from various precedents that preceded it. Regardless, there remains the question of whether that issue will indeed even be teed up. And that will really come about if the Trump administration fires a federal government, a Fed governor, without cause, without any kind of rationale. And that is not what has happened, as of course, in the removal of Lisa Cook. And there, as my colleague Sam Bray alluded to, there's a question of whether it'll come to the Supreme Court this term. That'll just depend on how the litigation below goes. Will she win at the district court level? Will the government seek emergency relief from the DC Circuit if they side with her? Of course, if they do, then I think we could potentially expect a ruling from this court. And folks might be interested in talking more about that. For what it's worth, on the merits of this question, I think that it'll depend on, again, the court's willingness to really deploy Loper-Bright and interpret what for cause means in the statute governing the Federal Reserve's removal restrictions. I think there's a good argument that that term is broader than inefficiency, neglect of duty, and malfeasance, which appears in many other removal statutes. But I think that the court is going to weigh, as it did in Trump versus Wilcox, a lot of the practical implications of a ruling that basically gives great deference to the president in interpreting that term, or a ruling that says that a statute like that can be carried out by the president without any kind of process or opportunity for Cook to contest the facts. Essentially, I think the court will be searching for a way to interpret the statute that creates some daylight as to what it means to remove for cause versus at will. And in doing that, it's going to have to figure out sort of what kind of interpretations of that are beyond the pale, whether it's for private behavior that occurred before the occupant of the was in office, and so on. Okay, so much for the near complete victory of the unitary executive. Second, let me just touch briefly on the neutered major questions doctrine. I think my colleague Kurt Bradley will say more about this. As a lot of folks know, during the Biden administration, this doctrine was used to strike down a number of major presidential initiatives, including a COVID vaccination and testing mandate for workers at large employers. There was a rule addressing carbon dioxide emissions from existing natural gas and coal-fired power plants. But since then, and one could either charitably argue that it was because of doctrinal dynamics, with Loper-Bright taking the pressure off the courts in finding ways to cabin the executive branch, or if one wants to be more cynical, one could point to a change in administration. But various members of the court since, as I've already alluded to, have suggested that the doctrine may not be deployed with such force. But there are huge open questions about the extent to which this doctrine applies to presidential delegations and foreign affairs, again, as my colleague, I think, Kurt will discuss. As a side note on this, insofar as the major questions doctrine can be understood ultimately to call for more congressional involvement in administrative control over agencies. That is to say, in the text of the statute, making clear the policy decisions. I think it's worth noting in this context the dismissed case of Department of Education versus career colleges, which as I mentioned, dealt with a borrower defense rule from the Biden administration. Basically, what was at issue was a rule that allowed for more administrative process for the Department of Education when it was determining these asserted defenses. On August 8th, the SG filed a letter requesting that the case be dismissed in light of the July 4th passage of the One Big Beautiful Bill Act, which essentially stated that these borrower defense provisions of the rule at issue in this case shall not be in effect. So this is a real case of Congress in legislation coming back to basically nullify a rule, which is exactly the kind of dynamic that the court says that it wants to encourage with some of these doctrines. And so insofar as the successful passage of this bill, it could reflect the reality that what matters is not so much the separation of powers, but the separation of parties or lack thereof. I think it illustrates, again, the augmented power of a president who can enforce party discipline, here in the legislative context. And on this theme, I want to say a few words about National Republican Senatorial Committee versus Federal Election Commission. I think one way to understand the case, which deals with the constitutional question of whether statutory limits on coordinated party expenditures violate the First Amendment. I think it raises the question of the extent to which should the court overrule a precedent that basically allowed for, or rather narrowed party discipline, then it effectively will allow presidential control to be augmented over federal elections when the president can control the party. More specifically, the case calls for an overruling of FEC versus Colorado Republican Federal Campaign Committee. And I think the Sixth Circuit here was correct that it is in tension with a lot of the Supreme Court precedents in this space. So I do expect the court to, if not overrule it, to narrow it substantially. The Trump administration itself has refused to defend the statute. And I think it's important to, in this context, appreciate the other ways in which this administration has augmented control over the Federal Election Commission. In other words, if the court strikes this statute down as unconstitutional, the practical implication will be that presidents who have control over their parties can exercise a lot more influence. This is, again, against the backdrop of the Trump administration, first of all, subjecting the Federal Election Commission to centralized presidential control through the Office of Information Regulatory Affairs, or OIRA. Basically, OIRA now can review the rules of the FEC for the first time. And in addition to that, Trump has recently dismissed a Democratic commissioner of the FEC, leaving it without a quorum. So the FEC is essentially neutered in practice. Finally, if that entire picture has been kind of three dynamics that will all serve to augment presidential control, I think the wild card here a little bit is how the Loper-Bright will continue to be develop. That is, in other words, how much will judges actually engage in independent statutory interpretation? And this case and this precedent is implicated in Orellana versus Bondi. The question there implicates a deep circuit split of whether courts of appeals must defer to Board of Immigration Appeals judgments that certain sets of facts do or do not demonstrate mistreatment severe enough to constitute persecution for asylum eligibility. Essentially, in this case, the petitioner asserted that his family had been threatened and attacked by a violent cartel, and BIA determined that these threats were insufficiently menacing, and then the First Circuit essentially deferred under a substantial evidence standard, which was split with a number of other circuits that called for de novo or independent statutory interpretation. And so, not surprisingly, in this context, the petitioners here are citing Loper-Bright to say that there needs to be more de novo review of the BIA. Unsurprisingly, perhaps the Trump administration is arguing that deference is warranted in this context. And again, we must understand the context in which this is all occurring. Trump has removed or forced into retirement over 100 of the 700 available immigration judges and engaged in a number of other mechanisms to assert control over immigration adjudication. So this is a situation where the court could find that there is more de novo review by a federal court of the executive branch and potentially deliver a win to the petitioners and constrain the Trump administration. For all these reasons, I expect this term to have some major precedents on the scope of presidential power, leavened only by the still uncertain status of Loper-Bright and the major questions doctrine. So on that note, I'm going to now turn the discussion over to my colleague, Professor Kurt Bradley.
Thanks, Jennifer. So I'm going to focus my remarks on a couple of very high-profile cases. Most people watching are probably at least a little familiar with these cases. They've been in the news quite a bit. They are not currently on the Supreme Court's docket, but are very likely to be on the court's docket soon. Certainly the first one I described almost certainly will be on the docket soon. They're both about presidential power, something Jennifer was talking about, but in the foreign affairs realm, at least in part. I think these cases are going to present some significant challenges for the Supreme Court. One of them, but not the only challenge, is that they really show kind of a conflict between the court's concerns about presidents claiming lots of novel powers under statutes that don't specifically provide for them. That's something they've expressed concern about in recent years. But there's some conflict in these cases with that concern and the usual deference that the Supreme Court has given in the foreign affairs realm to presidents. And how those two principles work themselves out will be very interesting to watch. The first case is about Trump's tariffs, VOS elections versus Trump. There are out there a bunch of trade statutes that regulate tariffs and allow the president and the executive a lot of authority to move them up or down in various circumstances. Importantly, Trump has not used those trade statutes. They have lots of procedural requirements that he didn't work through. So instead, he has invoked an emergency powers law from the 1970s. We call it IEPA, International Emergency Economic Powers Act. And it is a broadly worded statute, and it allows, when there is an emergency, allows presidents to take lots of different actions concerning foreign property and transactions from abroad. To trigger it, a president has to declare an emergency, and the statute does talk about it having to be some unusual and extraordinary threat emanating from outside the United States, threatening to the national security, foreign policy, or economy of the United States. And presidents have used that statute a lot since the 70s, often in response to human rights abuses in other countries or conflicts in other countries, sometimes in response to threats, particularly national security threats, like the Iran hostage crisis was an early use of the statute when the U.S. personnel were taken hostage. President Carter froze assets of Iran and other things under the emergency power statute. We've had about 50 years of experience under IEPA. It has never, until now, been used to impose tariffs on imports. And obviously that has changed with Trump using IEPA. He actually issued a bunch of emergency power orders, some about opioids, but the most wide-ranging one is a claim that we now have an emergency due to an imbalance of trade. And to deal with that emergency, he's imposing largely, basically worldwide tariffs of various sorts to address the trade deficit. And the basic question is, does he have the authority to do that under this emergency statute? No one really argues that he has the authority on his own. He really does need statutory authority. This is about commerce. And by the way, tariffs are kind of a tax. All of those powers are in Congress. There really isn't any reasonable claim that they're in the president. But he claims the statute gives him that authority. The Court of International Trade, where it went first, the three judges found that he did not have the authority, said the tariffs were invalid. Just the other day, the Federal Circuit issued its appellate ruling, 7-4 against Trump, finding, like the Court of International Trade, that IEPA does not give him sufficient authority to impose worldwide tariffs on products. We're talking about hundreds of billions of dollars or more in tariffs. And the court emphasized, as you might expect, that there are other statutes that deal with tariffs. There are lots of procedural requirements that Congress thought were important. And that's a suggestion. They didn't want a president to have an open-ended worldwide tariff authority without any limitations, basically, is what the Federal Circuit reasoned. And to tie into something that Jennifer talked about, the court also invoked the major questions doctrine, which the Supreme Court has employed in recent years in various contexts, to say one would expect, if Congress wanted to give worldwide tariff authority with very little limitations to the president, one would see some reference to that in IEPA, and there's no specific reference in the statute. Now, there is some language in IEPA that says if there's an emergency, presidents can regulate ... importation. And so Trump's lawyer's arguments is a tariff could be viewed as a type of a regulation of an import. The Federal Circuit's response was Congress should be more specific if it wanted to do that, particularly given that no president until now has claimed that, even though presidents have claimed lots of other broad powers under IEPA. And the phrase they had in the opinion was these tariffs are unbounded in scope, amount, and duration, and one should not read IEPA to authorize such a thing. There were 4 dissenters, and so certainly not unanimous, who thought regulated importation is broad enough to cover tariffs. And they said the spirit of IEPA was to give presidents lots of tools to deal with emergencies, and tariffs could be viewed as a type of tool. The Trump administration views this as a very significant case, not surprisingly. Solicitor General has asked for a quicker than normal cert decision from the Supreme Court, and if they get cert, oral argument in November. At least hundreds of billions of dollars or more are at stake, and they may need to refund those billions of dollars if they lose in the Supreme Court. So that's a very significant one. I think unless something really surprising happens, that one's going to be decided by the Supreme Court this term. It could end up being maybe the biggest blockbuster case of the term in terms of presidential power and the like. The other one has been also working its way through actually a bunch of lower courts, not quite on the Supreme Court's docket, but it has, to go back to what Sam was talking about, it has met the Supreme Court's emergency docket, this other case I want to mention, a couple of times, and somewhat dramatically. It's a case involving the Alien Enemies Act. And the particular case I'm thinking about is WMM versus Trump from the Fifth Circuit. And there's been some recent events, some people you may have read in the news, that kind of relate to this, which I'll mention. So there is this criminal organization from Venezuela, the Tren de Aragua. The Trump administration has labeled that organization a terrorist organization. It apparently engages in lots of criminal activities, including drug trafficking. And Trump has invoked in a proclamation this Alien Enemies Act to try to remove from the United States any alleged members of this Tren de Aragua or TDA. I won't go into the history, it would take too long to the statute, but it's been around since the 1790s, passed right as the United States was about to go to war with France. And it says presidents can remove, quote, enemy aliens from the U.S. If another nation there's a declaration of war against another nation, or that nation has engaged in an invasion or predatory incursion in the United States. If that happens, the president can then remove all the citizens of that enemy country. It's only been used by presidents until now 3 times, all in declared wars, War of 1812 and then the 2 world wars. So it hasn't been invoked recently at all until Trump invoked it to allegedly have the power to remove any alleged members of this Venezuelan gang or criminal organization. Without having, I should say, to work through any of the usual immigration laws, which, of course, if these are criminals, there are provisions to try to remove them, but he doesn't want to work through those statutes and claims the authority. And what's the argument? We're now being invaded or subject to a predatory incursion by the Venezuelan gang. Now, by the way, that's not enough under the statute. It's actually written about war with another nation. So his claim is that the Maduro regime in Venezuela is sponsoring effectively the gang for these incursions that harmed the United States. And therefore, that's kind of like having a military conflict, and he can remove anybody who happens to be a member of the gang. This has gone to the emergency docket twice already. The Supreme Court kind of carefully navigating this issue. The first time said, sorry, some people filed in the wrong districts. You got to go to Texas. Interestingly, in the same opinion, unanimously said, but they get due process. You've got to give them notice, opportunity to be heard, opportunity to challenge this. That was kind of gratuitous, but quite important. And then we may all remember from the Supreme Court in the middle of the night really stopped some buses from going to the airport in Texas to remove some people saying they had not been given due process and had to be given that, although taking no ultimate view about the merits. So just recently, the Fifth Circuit, normally a very conservative circuit, I should say, ruled against the Trump administration 2-1, saying this is a wartime statute. It's for military type incursions, not for a criminal organization. And given its history, context, they looked at dictionary definition of those terms from the 1790s. And so the Trump administration just lost this issue. There's a very long dissent. I will not try to summarize it. It's 130 pages long. I'll summarize in one sentence, which is judges should not second guess the views of the president about what one can do in response to a national security problem. Basically, that's the gist of a very long dissent. But there's one point I wanted I think the dissent kind of almost accidentally highlights, but is really interesting. If the Alien Enemies Act has been correctly invoked as to this Venezuelan gang, if you read the terms of it, it means that any Venezuelan in the United States, even lawful immigrants, are now subject to immediate removal. The statute is class-wide as to any citizens of the so-called enemy state. It's not written to be targeted in the way, in fact, the administration is trying to use it to target just the alleged gang members. That might be another reason to not go with the Trump administration, is just the impact would be quite dramatic. Final point. We may have read it in the news. I think the case may have just gotten more complicated in an alarming way, which is the recent, from this last week, attack of the United States on this vessel, which allegedly was operated by members of the TDA organization, allegedly engaged in drug trafficking. They targeted it with a military strike and killed a number of people. That's an unusual thing. Many people would say it's a clearly illegal act under international law, but interestingly, may give the administration kind of an argument that even if you didn't think we were in a military incursion or conflict before, look at this military action that's just occurred. I think that's a bit of more than a bit of a bootstrapping kind of an argument, but it does perhaps complicate the national security overlay of this case. Challenging cases, as I said, I think for the Supreme Court. Maybe we'll find, to go back to Sam's remarks, that those wins on the interim docket for the president were ways that the Supreme Court was saving its powder for some significant rejection of presidential authority perhaps in these cases. I do think that the arguments against the Trump administration are pretty good in those cases, as obviously the lower court judges thought. So there's certainly a real chance that the administration will lose one or both of those cases, which would be a significant pushback by the Supreme Court if that's what happens. So I'll just stop there and I'll turn it back over to Dean Chilton.
All right, thanks everyone. Now, I've been getting questions both through when people registered, that was the option to submit questions, as well as the Q&A function. And I'm going to try to group questions together to some of the themes that have been coming out. Now, I think the most common question that we've received is some variant of curiosity around the use of the shadow docket, emergency docket, interim docket, and trying to understand it. I think we've had questions about why it's become so common. What's the relative merits of the use of the interim docket so aggressively? And then perhaps the one I'll focus on, what do we anticipate in the upcoming term about the use of the shadow docket? Now, I know all of you at one point mentioned it in your remarks, but I'll ask just directly focused in on this substantively. What do we see for the use of the shadow docket's changes in the upcoming term? Sam, how about you first? Gladly.
So I think one of the changes is going to be they're changing what they're calling it. So I think they may move to the interim docket, but we'll see. Another a more substantive change, a really important question, is you could imagine two different equilibria for how these decisions go for the court. One is the justices treat these as kind of precedential, maybe not fully precedential, but pretty precedential, and they explain what the reasoning is to give guidance to the lower courts. Another equilibrium would be they're just stays. They're just like try to keep things in place. They're not really supposed to have legal significance as precedents, and the justices don't have to explain them. Each one of those can make sense. But the problem right now is they're sort of gyrating back and forth between those. And I suspect there are some justices who want one and some justices who want the other, and some who aren't sure, or depends on the kind of case. And so I think one of the real tensions, one of the confusions for the lower court judges is, what are we supposed to do with these? And which of these two models is the court going to go with? Because the court has been changing what the model is. And so that's a big question I have for this coming term is the court going to settle on one of these models, or is it going to keep bouncing back and forth?
I'll just add one additional thought. When the CASA decision came down, there was a lot of discussion. Would the restriction of universal injunctions also have a side benefit potentially of reducing all of this work on the interim docket or emergency docket? A lot of us at the time thought probably it would not reduce the pressures on that docket, at least immediately. Some of the reasons Sam gave earlier, which is there are all these other ways of getting broad relief that the court, at least so far, has not pulled back on. He mentioned class actions and vacating administrative orders. State standing is another one, I should say. That's been used in some of the cases I described, that states have been allowed to sue, for example. And some of that the court could continue to trim back on if they decide to, and maybe that would have an effect. But my bigger thought is I have been teaching separation of powers law for over 30 years. This administration, whatever your views about them, is more aggressive on almost a daily basis about the edges of presidential power under statutes of the Constitution than any president that I've seen. And there's no reason to think that's going to change, in my view. And that puts a lot of pressure on the emergency docket, because when you're always at the edges of the law, and often I think over the edges of the law, you're going to get lots of lower courts, perfectly good judges, reasonable judges, finding that they need to give some kind of equitable relief. And now the court could let that happen. My own view is probably like Sam's. I think the court ought to let more of that just work its way through the courts, but they have not been able to resist the temptation. I don't think they will, for major nationwide presidential programs, to just let the lower courts freeze things in place. So my view is, if we don't see a change in behavior in the administration, we're unlikely to see a big reduction in the pressure on the court.
Let me jump in there and ask on this, I'll go to Jennifer with this. The second, I think, most common group of questions is around where Kurt just left off, which is something like the relationship between the Trump administration and the court. And I think we have three different kinds of questions around this. One kind of question is, as Sam noted earlier, that the Trump administration has been on something like a 20-case win streak at the Supreme Court, which then seems in tension, perhaps, with what Kurt just said about the administration has been extremely aggressive on the interpretations of a number of issues, and also at times ignoring, disregarding, setting aside some of lower court opinions, issues, or orders, or seeming to at least signal willingness to ignore the courts. And then finally, related to these two facts, this, the fact here that the Trump administration is winning, but also signaling willingness to ignore or to challenge the courts, is it reasonable to say that the court is in some way allowing, facilitating, tolerating something that might look like an erosion of the rule of law? So how should we think about the Trump administration's political relationship to the courts, Jennifer?
Yeah, so let me just talk at the intersection of this, the previous question and this one, just as you were segging us to. I mean, so I was going to throw in some just an empirical portrait of what the interim docket is looking like. So Tara Lee Davis at SCOTUS Blog just did this great empirical look recently. And just on this theme, there's a few things that kind of stand out. So one, indeed, it is the case, not just public perception, that the court is granting more relief on the docket. So some of the numbers that she finds, for example, is that, if we go back to 2023 to 2024, there was about 23% rate of relief. Under the Biden administration, the rate dropped to 31%. And now the Trump second term, which is still in its relative infancy, the rate is now higher at 67%, right? And we've had all these theories as to why that could be occurring, whether it's, more aggressive interpretations by the president and whatnot. In addition to that, the empirical study also finds that these do tend to skew in a little bit more of a conservative direction. Now, that is open to a lot of interpretation of what that means. We've talked about, some of the ways in which the seeds of unitary executive theory have been in place for many, many years. And so there's just been like more vehicles and opportunities, right, for the court to kind of develop a lot of those things, again, whether it's on removal or the scope of the president's control over foreign affairs and so on. And then finally, I think one finding that I think is interesting in this context is to ask sort of like what our baseline is for evaluating the shadow interim docket. And one finding is that, relative to even a couple years ago, the court is explaining more of its reasoning, on the docket, on the margins. Now, you and I could argue it's still not enough, but there seems to be, for whatever reason, the court is doing more of that explaining, probably because it is using more of these as precedents in a lot of its actions here, and it's also using those interim docket rulings to chastise the lower courts for not following the direction of where those interim rulings are going. So anyway, so this is all overall just to talk about this relationship between the president and the interim docket in this way. I think it speaks to again, just the court picking up and seeing opportunities to carry forth a lot of its doctrinal precedents.
And Adam, just to add a little more based on another part of your question, and we got a written question on this. The question was something like, does the Supreme Court take account of the likelihood of compliance or the likelihood of political retaliation when it decides these important cases? You get a lot of debate among academics. My own view is clearly yes. And it has always been the case, is what I would argue. It started with Marbury versus Madison, if not earlier. Everybody probably remembers that, knows about that case, where, the Supreme Court they just had their practically entire term canceled by Congress right before Marbury. There was a huge confrontation with the Jefferson administration. There was talk about impeaching Supreme Court justices, what sounds pretty familiar. And back in the early 1800s, and the Supreme Court found a way to preserve its authority, but not have a confrontation with the Jefferson administration. That's early 1800s. We've had many crises or mini crises with the court at various times. I do think we're in another one of those periods right now where there's a lot of talk about disregarding decisions or impeaching judges. Chief Justice Roberts spoke out about it recently, and it would be very unlikely the court does not think about that when it thinks about the scope of the decisions, when to decide, how broadly to decide, and how much of a direct or indirect confrontation to provoke. I think we've seen it. In the Alien Enemies Act case, they were very careful to both kind of give the administration a win while in dicta giving the individuals some rights. And then when the middle of the night order, very careful to say they're not addressing broader questions. And then there was another Kilmar, Abrego Garcia, remember him? He was accidentally sent to El Salvador. They said, please facilitate his release, but they didn't push very hard. Eventually was brought back, even though at first Trump said they weren't going to do it. So it is a very careful balance. Now, do you lose the rule of law? Well, the danger, of course, is if you provoke too much, you lose it a different way, which is you lose your power. So I think the court has to balance being effective and authoritative without going too far, so far as to undermine its own legitimacy or capabilities. And I think we're in one of those periods again.
All right. We have time for one last question, which might be slightly switching gears to some themes that we haven't covered on, but is a question we've been asked that I thought I would ask you about, which is one aspect of the Trump administration's political agenda has been both to have an anti-DEI agenda and also what is at times been called a war on higher education, or at least an aggressive posture towards educational institutions, the private institutions' use of prior diversity practices, et cetera. Do you expect any cases related to this to make it to the Supreme Court this term, or the Supreme Court to get involved? Or what's the next way we might anticipate the Supreme Court taking the next stance on the progeny of cases that goes through SFFA and others? Anyone?
I don't have a strong prediction, but to the degree the cases settle out and the universities make deals with the administration, then they don't get then they don't get litigated. So that's a constant pressure. And I mean, I'll make one other substantive point here. This is at the intersection of massive executive power over discretionary enforcement of the law and federal funding, combined with the need for the executive to respect constitutional principle about freedom of speech, not punishing enemies, things like this. And so the tension we're seeing is our legal culture and Congress have given enormous power to the president at this point, but it presumes a commitment to constitutional principle, which we're not seeing. And so that's the tension, and sort of unsurprisingly, you're getting a lot of settlements.
All right. Well, we'll end there. Let me note that throughout the year, for our alumni, both of the law school and the university more generally, that are been on this webinar, that we're going to continue to have nearly every month additional virtual programming as well as in-person events in cities around the country. We're having an event in Chicago September 30th, in DC on October 9th, New York October 29th for in-person opportunities to talk to the faculty about these and other issues. So I hope you join us both in person and on future webinars. I'll also say that although we touched on injunctions, tariffs, Humphrey's executor, a range of topics, it's not everything, of course, that the support court is going to address, nor all of the topics that our faculty are involved in. For instance, our criminal and juvenile justice clinic is deeply involved in a string of federal cases that are going up to the court, involved in the federal judge's ability and power to reduce sentences. So you'll probably be hearing more from the law school on that line of cases as well. Now, with that, I thank you for your time and your attendance. And I also invite our members of the media to stay back a few minutes, and we'll continue to take a few more questions if anyone has them. Thank you all.